All right, good morning, everyone. As you just heard, Elan Dunaev, EJD Law Group, as you can tell from the name, law firm. A little bit about my practice. These are my practice areas, with the first three being the definite largest ones, which is construction, business, and real estate, hence why I'm in this group. Insurance coverage is shortly right behind that, and then personal injury, definitely the smallest part of my firm by a lot. It's not something that I really talk about too much. I don't really advertise about it, but it is something that we do. I have experience in it. I'm able to handle those matters as well. So if any of you ever know anyone who needs assistance with a personal injury, anything like that, you can still think of me. I do handle those matters as well. But this is pretty much the expertise of my firm and myself, and that's kind of what I try to stick to. And you know what, before I even got into this, I want to just say a little bit something. I'll be real short about myself and my background. Most of you in this room know me, but for those of you that don't, I come from parents of immigrants. Both of my parents were born and raised in Russia. They came here. My mom was 15. My dad, and she came with her entire family. My dad came here when he was 17. He left Russia. He ran away. He came by himself. He left his entire family in Russia, which, you know, I always tell him, I don't know how you did that. I don't think it's something that I could do. Didn't speak a word of English, didn't have any money. But he said, I don't care. I want to go to America and, you know, live the American dream, as everyone says. So he did it. He, you know, went through Italy. He lived in Italy for 4 months. He told me some crazy stories that he had there. And then finally made his way here. You know, and then obviously ever since he got here, he, you know, worked his butt off to, you know, build something for himself and his family. And I look up to him a lot. His parents didn't come to the States until my brother was born in 1981. So they were in Russia for a while, even while he was here by himself. So a little bit about my background. My wife is also of similar background. She's half Ukrainian. Her mom's from Ukraine. Her dad's from Russia. Yes, that still works out. I know it's kind of crazy, but even though half Ukrainian, Russian with all the stuff that's going on. So we come from the same background. I've been married almost 3 years. As most of you know, I have a new son at home, little babies, which has been keeping me really busy, and that's why I haven't been here as much. So yeah. But so that's a little bit about me. I'm not going to spend too much more on that, but I did want to quickly go through that. So with respect to construction, which is the largest part of my practice, these are just some bullet points of some things that I handle. You know, I'll say within the construction law realm or industry, I pretty much will handle anything. I have a lot of experience in doing it. I mean, again, there may be some issues that could come up at some point where maybe I would say, you know what, let me refer you to somebody, but it doesn't happen too often, at least in construction. But, you know, stuff like contracts, drafting contracts, revising contracts, disputes, all sort of disputes, contract delay, payment, change order disputes. Mechanics liens is a big one. It's actually something I'm going to talk about a little bit later, so we'll go more into that. Bond claims, all kinds of different supplier claims, defective construction, and also litigation of construction defect and related claims. The next area of my practice, business law. So listen, we're all, for the most part, at least business owners in here. So in addition to, you know, the specific thing that we do in our business, you know, most of the people in this room are contractors, but we also need to make sure we're running our business properly within the confines of the law and doing, you know, the things that give us the greatest chance of success as business owners. So I handle a lot of those things on the legal aspects, business formation, you need to incorporate, LLC, whatever it may be. You know, I can provide some guidance on which entities I think would be best, alongside definitely Ben and Sonia, because I would always say, you know, talk to your CPA also, because they generally can tell you which way to go, which are best for your finances, which I don't really get into the tax stuff. I'm not a tax lawyer, so definitely I say consult your CPAs. Again, contracts, any sort of disputes, partnership disputes, Buy-sell agreements, if you are in business with partners, it's always something that's recommended to be done. I handle those. Payment stuff, you're not getting paid, I handle all that, and litigation as well. And pretty much everything also that I do, it's both transactional and litigation. So you'll see that, I'll pretty much litigate anything. I will say that I am not the attorney that is gonna come in and say, if they come to me with a problem and say, Elan, what do you think we should do? I'm not going to be that guy that's going to say we need to go file a lawsuit tomorrow and we need to sue the hell out of these people, because 9 times out of 10, that's not what's in the client's best interest. I mean, sometimes, you get to the point where you have no choice and we say, you know what, we kind of have to sue them if we want something to happen. But 9 times out of 10, that's not the first thing that needs to be done. And there are other ways to resolve problems out of court, which is much cheaper for clients and it's much quicker. So I am definitely the attorney that's going to try to resolve any problem out of court that I can, try to go down any path that I can to resolve something in that way, and we leave litigation for last resort. But personally, I do love litigating. I do love going to court. I love being in front of a judge. I like deposing people, so it's fun for me. But again, not always in the best interest of the client, so I try to stay away from it. And again, it gets really, really expensive, and it's a long, drawn-out process more often than not. Real estate, acquisitions, dispositions, development, landlord-tenant stuff, that's been happening a lot lately. So I've been handling a lot of those. There's been an uptick in that, both commercial and residential. Title issues, foreclosures, easements, also litigation, and I've handled a few broker's liability actions that also I've had to deal with recently. Then for my insurance coverage practice, I pretty much handle all kinds of claims. I'd say the ones I definitely see the most, by far water damage is the one that I see the most. Most of the cases I have are water damage. I have some wind, some smoke and ash. I think I've resolved all of those back from the fires several years ago. I had a lot of those cases. I think I may have a couple of those still, but I think, those have pretty much all been resolved, and, hopefully, again, there are no more fires, so we stay away from those. But yeah, any kind of insurance claims, I help the homeowners with, and just to provide a little bit more information on that, it's, somebody has a leak, damage to their house, for example, or business, doesn't have to be just residential. They make a claim to their insurance company, and the insurance company either denies the claim, says we're not covering it, or maybe says I'm only going to pay for a small fraction of the claim, the rest is not covered. That's when I step in and I help them go up against their insurance carrier and get them the compensation that they deserve. I mean, again, there are sometimes I do get clients where I'll look at the policy and say, unfortunately, it's not covered, but I definitely will give them an assessment and let them know if there's something that we can do. And then lastly, personal injury, again, not going to spend too much time on it, but any sorts of accidents that result in a personal injury I can handle. I don't handle mass tort actions, so the commercials we see, have you taken this drug and then your leg falling off or something like that, call me. I don't do that. Other than that, though, pretty much any of these I can handle. So that's about my firm pretty much in a nutshell of what we do. What I want to talk about next, and something I talked about a few years ago, but I figured it's really, really important, especially in this room with a room full of contractors. Hopefully it's something that you guys don't have to use, but if you have to use it, it's a really good tool, and it's important to know the basics and the requirements for mechanics liens, because if you have a client that's not paying you and you did a bunch of work for them or you supplied a bunch of materials for them, it's a way to get paid, and it's a much better way to get paid than I'm just going to sue you for breach of contract. Because, I mean, again, that's a viable claim as well, but when you actually can put a lien on someone's property, it has some more teeth, and people generally don't like when liens are placed on their property.
Solar.
Yes, exactly. So it's an effective way to get paid. So I'm going to talk a little bit about that. For, again, I know not all of us this is applicable, but for most of the people in this room, So there are two things. There's mechanics liens and stop notices. They're very, very similar, but have a few differences. The main difference is a mechanics lien attaches to the actual property itself that is being worked on. That's why you go down to the county recorder's office and you record the lien on the property. And stop notices, they actually attach to funds that are held either by the owner, or if there's a construction lender on the property for some bigger jobs, it puts a freeze on those funds. So it doesn't really have anything to do with the property, but it's actually the funds. Who can record? It's really anyone who performed work on the job or on the property or supplied any materials. So anybody who did any of those things on the job, you do have lien rights in California. Another difference between mechanics liens and stop notices are whether the project is public versus private. Stop notices are available on both. Mechanics liens are only on private projects. So if you're doing a job for the city or the county, mechanics lien is not an option, but you still can file a stop notice. So about both of these, they have very strict timelines and requirements, procedures you must follow, and if you miss one of them, you lose your rights. The first requirement is serve a preliminary notice within 20 days of starting work. So this is for mainly subcontractors, because the goal is by the legislature in California is, by not all property owners know everybody that's working on their house. Generally, they hire a general contractor, the general hires a bunch of subs, and they don't necessarily know who all the subs are. Some do, but that's why the subs need to serve a preliminary notice on the owner to just kind of let them know, hey, I am working on your house and I do have lien rights. If you don't do it, you lose your right there. Again, general contractor, the direct contractor, does not have to serve preliminary notice because the owner obviously knows that you're working on their house. They're the ones who hired you. Who must be served? Owner. Again, if you're a subcontractor, you got to serve the GC as well. And if there's a construction lender, serve them as well. Service has to be done by a specific way of the preliminary notice. It can be personally served, obviously hiring someone to show up to your door or your office and say, here you go. Or you can do it by mail, but it has to be registered, certified, express, or overnight. So you can't just put a little cheap stamp on it and throw it in your mailbox at home. That won't be sufficient. And again, you do one thing wrong, whole process is done. Time limits, also super important of when you have to record your mechanics lien by. If there is no official notice of completion filed on that project, which most don't, then it's 90 days within actual completion of the job. So again, when the entire job is done, there's no more work to be performed. 90 days within occupation of use and cessation of work. So person's actually starting to use the property and then no more work happens. Then there's cessation of labor for 60 continuous days. So if nothing happens on the project for 60 days, then that 90-day clock starts ticking. And then cessation of labor for 30 continuous days and recording a notice of cessation. So it really depends on how the project is done. Generally, 90% of the time, the top one is what applies, because most people are not recording notice of completion. It's, hey, when did the project get completed? Or if you're a sub, when was the last day that you completed work on this project? Whatever that day is, we calculate 90 days from there, make sure that it's recorded. Again, you want to be safe. Do it early on. Don't wait till the 90th day, but you have 90 days.
So if the work didn't get completed, right, then it's 60 days, and then the 90-day clock starts.
Correct. That's exactly what it is. So it ends up being 150 days.
Yeah.
But, again, I always, because, people will fight this. So I always say, just when did you finish work? Get it done within the 90 days. And if you know you're going to do it and you need to do it sooner rather than later. Let's not wait. It's, it doesn't, don't take any chances. Pierre?
But if you work directly for an owner, you don't need to file.
You don't need to do the prelim, yeah, but you still need to record the lien, of course, within the time, yeah. But you don't need to do a preliminary notice because, again, they know you're working on the job. So then on the few jobs where there is actually a notice of completion, it's either 60 days within that notice for prime contractors, so the GCs or direct contractors, or 30 days of notice of completion for subs and suppliers. Now, after you record the lien timely, then you have 90 days from that date to actually foreclose on the lien. Foreclose on the lien just means you need to file a lawsuit in the Superior Court for foreclosure of mechanics lien within that 90-day period, or again, the statute of limitations expires. If we have to do that, we throw in other things such as the breach of contract claims. There are other accounting claims that we can make, which again, the statute of limitations is much more. A breach of written contract in California is 4 years. Breach of oral contract is 2 years. So mechanics lien is a much shorter time period, but a much stronger claim. So I would say, do you lose your right to go after someone if you don't foreclose on the lien properly? No, you don't. You can still go after them for breach of contract, but it's not as strong. So I always recommend doing this if a contractor is at the point where they have to. So it's important too. Only licensed contractors have lien rights. This is extremely strict in California, especially. The Business and Professions Code 7031, I'm not going to read it all for you, but essentially it's saying that if you are not licensed, you don't have any lien rights. So you cannot record any liens. I mean, you can, I guess. The county recorder's office will pretty much accept anything that's proper form, but it's going to hold no weight at all. And, as I'm sure all of you know, there's strict requirements to be considered licensed. So just because you have a specific license with the CSLB does not mean you can perform work that's not within that license. If you do that, you're considered unlicensed immediately. If you don't have proper workers' compensation insurance, you are considered an unlicensed contractor in California. There are a lot of things that you can do. You may have that license on paper, but if you're doing some of those things wrong, you will be considered unlicensed under California law and then have no lien rights, and other problems can arise too. So that's why it's always important to make sure you have the license, you're doing work only within that license, and you're doing all the other things required by that license. Business and Professions Code 7031B is actually a real scary one, especially for unlicensed contractors. It just essentially says that an unlicensed contractor cannot sue a property owner for work, let's say that he hasn't been paid for or she hasn't been paid for, because they have no rights under California law technically. So they literally, if an unlicensed contractor or someone who's considered unlicensed files a lawsuit, says, I remodeled your entire home and you didn't pay me, the homeowner could give you the bird really and say, sorry, you're unlicensed, and that's literally what the law, says. Ben?
So Elan, kind of curious where the line is somebody being a contractor versus not. I know a lot of handymen aren't necessarily licensed, and so let's say you talk to a neighbor and say, hey, I've got a light fixture or something like that I'd like replaced. You purchased it at Home Depot or some other retailer and say, hey, I can fix that. Pay me $20 or $30 or something. I'll swap that out and I'll do just a tiny bit of touch-up painting because it doesn't match up exactly. I think for most people would consider that person not necessarily be a contractor. It's a very small type of job versus somebody's a handyman trying to paint somebody's entire house. I think would be clearly, no, you should be a licensed painter as an example. And so where is kind of the line there of, who's a contractor?
It's $500.
Yeah.
Anything, is it $1,000?
I think it used to be 500.
I thought it was 500.
It was 500 for
Okay.
sure.
Okay, I
I
haven't
think
gotten
it's
updated
1,000
on that.
now.
I believe it is 1,000 now too. So yeah, it really is. Are you doing, like you said, these $20, $30, maybe $100 jobs? Then you don't fall under any of this. If you're doing jobs that are 1,000 or over, then yeah, you technically under the law, you need to go get that license. So that's really what it is. And the thing is also about 7031B, the scary one, and I've seen this. There could be a homeowner who gets the best construction work done by an unlicensed contractor. They're totally happy with their whole house, and then they find out they're unlicensed. They could literally sue that person for every penny that they paid them for disgorgement of all their profits. Even though they say, I love my house, it's perfect, you did such a great job. Doesn't matter. The court will order that person to repay them every penny, even though they're happy. So that's why California is really strict on this stuff. So for all of people make sure they're not doing unlicensed work. It's scary. And then lastly, waiver of lien rights. There are, I don't want to say most construction contracts, in a lot of them, there's an arbitration provision that says if there's any dispute between the contractor and the customer, they need to be arbitrated. They're not going to go to court, no trial by jury, anything like that, because it's a quicker process, not as formal. But I had, recently a case where I represent the contractor and opposing counsel, the homeowner's counsel, is saying, oh, but we have an arbitration provision in our contract, because we said we're going to record a lien if you don't pay. So you can't go after us. Your lien rights are gone. Look, the arbitration provision in the contract says that you waive all rights to go to court. California law, Civil Code 8122, specifically says that a contractor's lien rights cannot be waived by contract. And if there is a provision that says that in the contract, then it's unenforceable unless there is a conditional or unconditional waiver and release for a portion of the project. So I'm sure you guys have all been familiar with that. You do work on the project for that specific work you just finished. You get paid. If you sign an conditional or unconditional waiver and release as to that specific portion that you are getting paid for, then at that point you no longer have any lien rights for that portion. But
Well, you got paid.
right, exactly. You got paid, so you're essentially saying, I got paid, I have no lien rights. You can't, for some reason, go later and, I don't know, try to make any claims on that. But as you continue to work on the project for stuff that you did not get paid for, you still have lien rights. So it's not like you just lose it on the entire project. It's just for that specific
And
portion.
the release is dated, and
There's a
date,
specific
right, on
amount.
it.
Yeah, exactly.
As of this date, you've been paid.
Exactly, for this amount. So that's the only way really you can waive lien rights, but it's because you were paid. So there's really no claims. And then lastly, this is something that came up recently in one of my cases, so I want to talk about it too. Lately, California courts have been really hitting hard on arbitration provisions in their contracts. And California has a very strict requirement of what you need to put in your contract in order for an arbitration provision to be enforceable. So it's Business and Professions Code 7191 that would be applicable to, I think, most of the work that the contractors in here do. It applies to residential construction of 4 units or less. So if it's more than that or it's commercial, it doesn't apply, but for most this does apply. So if you have an arbitration provision in your contract that again says all disputes between you and the property owner have to be arbitrated, it has to be titled in all caps, arbitration of disputes, just like that. I didn't
Certain font size.
I didn't put in all the language that needs to be in there. I would need to, do 3 slides, and I'm not going to bore you with that. But the code section says specifically the language that has to be in there. It's in all caps, and to sum it up, it just says that I, the homeowner, the property owner, understand that I am waiving my right to, to take my claims to court. I am waiving my right to a trial by court, a trial by jury, and I, understand that my dispute will be decided by a neutral arbitrator. And again, it's long, but in sum, that's what it says. And then right after that, there needs to be a space for them to actually initial it, to show I, assent to this provision. If any of those things are not there, and it's not, like Aaron said, specific font size, courts have said, that's it, it's unenforceable. So you no longer can say we're going to arbitrate this dispute. It's going to go to court anyways. So most of the construction contracts I've been sent by my clients don't have the specific language in there. So we always make sure we change them. So that's another thing to look out for. And courts have been so strict on this that it doesn't even matter if the homeowner is an attorney. Actually, the seminal case for this dispute, it's from 2014, the homeowner was an attorney, and they tried to make the argument that, listen, I'm the contractor, this person's an attorney themselves, they obviously know what an arbitration provision is, what it means, so we shouldn't have to go through all these requirements. And the court said, I don't care if they're an attorney, if they're the president, it doesn't matter, you must follow this. So I want to just talk about that a little bit and bring it to your attention, because it does definitely apply to a lot of you guys and ladies, because it is important. So that's a little bit about my firm, hopefully a little bit of an educational moment for all the contractors in this room.
I got a question.
Yeah.
Do you specialize in real estate law?
I do.
Okay.
Yes.
I need to speak to you. 2 things. Do you do obviously cease and desist letters?
Definitely.
Something done. And then, I'm on a board over in the desert, and I'm having a very big problem with some board members, where they're not following the, regulations, the bylaws. I mean, it's like really bad. And currently, we're without a management company, and we're without a law firm, because they want to push it to the next seating of the board. So there's some several issues there. So do you specialize in like putting a firm foot down? I mean, we're at the tail end, and they're trying to push off meetings so they can seat the new board and they make decisions on the new property management. So do you specialize in that?
Absolutely.
Please talk.
Yeah.
That's
So
a real big issue.
then let's talk. Absolutely. Any other questions, Pierre?
Also, you know, when you finish the job and one of your subs especially supplies a lot of materials, make sure that you get a release from the supplier. Or if the subcontractor signed a release, make sure he signs the release when you pay him. I had that problem on a job, and about a couple of years later, I used a roofer, and the roofing supplier, contacted me and said, well, I want to get paid for the material.
The roofer hadn't paid his bill to the supplier.
Yeah, the guy didn't pay, and they took off and whatever. But I had a release, and the supplier had no recourse whatsoever.
Yeah. No, that's definitely a great piece of advice.
So this is more relevant to a commercial. I know there's a few folks that do some commercial work, but just to give you some context, so I understand that it can be common practice. Just as an example, know of an instance where a hotel chain had a project that they were developing, some raw land, building a hotel on top of that land, and got midway into the project. Don't know what the reason why was that the project wasn't penciling, and so essentially what they decided to do was to bulldoze what had been built so far, and on the basis that well, you have no property attached to the land now, you can't exercise that mechanics lien. What can people do who are aware that's a possibility of happening on a project,
Right.
do to protect themselves?
Honestly, the best thing to do is run a title search. The county recorder's documents; those are public records. Anybody can go in and see that and see a chain of title. So that would be the best way to protect yourself, to really know, okay, this is what somebody is purporting to say is with the property and who owns it and all this stuff. But the way to really go look at it is do a title search and confirm that is accurate, so you don't run into that type of a problem and your mechanics lien is worthless or against the wrong person.
Mm-hmm.
So that would be the best and easiest way to take a look at something like that.
And I can always do that. If anybody needs a title search, I have some software.
So there you go. Go to Paul.
Anybody that needs it.
I got a quick one. Commonly when I go to a call and there was a water damage, real common question that I get asked from the homeowners, will my insurance cover this? And typically what I tell them, I'm just gonna ask you if this is safe to say. I'm like, typically the insurance covers the damages caused by the plumbing, but they won't necessarily cover the plumbing itself.
So yeah, more often than not, that's absolutely right. When the insurance company, so again, an insurance policy covers things that happen, but not necessarily, it's not a maintenance policy, So if you have 50-year-old pipes that just, listen, they run their age and then, a small pinhole opens up and then, gradually gets a little bigger and it starts leaking and then it's a leak over time, they're not gonna, pay for that pipe repair, because they're gonna say, listen, these are 50-year-old pipes. It's not like something happened for the pipe to break in half.
Right.
So if something happened, I don't know, and something hit the pipe and the pipe snapped in half,
Right.
that's direct physical loss. That would be covered. We don't have these problems here, but from Midwest moving on east, exactly.
Yeah.
If it's cold, pipes burst all the time. That's covered. So yeah, here more often than not, the pipe will not be covered, but as you know, generally these pipe repairs are not that expensive. It's all the resulting damage from the
Yeah,
pipe leak
that's
that goes into the house,
typical.
and that's generally covered.
Mhm.
So unless there's another exclusion to exclude that, but more often than not, it's covered.
Oh, okay.
Yeah, so that is safe.
Okay.
All right. Oh, Johnny.
Once the lien is foreclosed on, does the contractor have any recourse in terms of delay? Because nothing really happens till they go try to sell the property, right?
You're saying, can you obtain additional money? Yeah.
For example, if I have a lien on the property for 2 years before they go try to sell it, does the contractor get any kind of?
Prejudgment interest.
Okay.
Yeah. So you do get prejudgment interest up to the point of judgment, and that's all calculated at the time of judgment. So certainly you get compensated for all that wait time.
So wait, so you lost me there. So pre-judgment, before the judgment, you get interest up to judgment, but after the judgment, if it goes 2 years before they sell, do you get any interest?
So correct. There's prejudgment interest and then there's post-judgment interest.
Okay.
So yeah, you aren't losing essentially all this time that you're waiting.
What's the
Yeah.
rate? Just curious.
10%
Oh,
usually.
shit.
Between 6 to 10. 6 to 10. Yeah. So that's why again those lien claims they're beneficial for contractors, and property owners don't want to deal with them. That's why these cases generally, even if we get to the lawsuit point, more often than not they settle pretty quickly because these homeowners know that, hey, if this contractor legitimately performed work on my home and I didn't pay them, I'm going to be screwed. I mean, again, unless the contractor is making lien claims that aren't legitimate, but so, yeah.
Okay.
Thank you so much.
Of course. Thank you guys.